Hi, my name is Dan Couvrette. I'm the publisher of Divorce Magazine, and I'm pleased to have Nissa Ricafort today with me on this divorce school seminar. Nissa is one of three founding partners of Broyles, Kite, and Ricafort. They're an experienced Indianapolis family law firm. Nissa has 17 years of experience herself, and she has assisted families through difficult transitions, including high-conflict custody proceedings, international custody disputes, and child support disputes. I advise you to visit Nissa's firm's website to learn more about her, because my little quick introduction is not going to do her justice. If you go there and look up her resume, you'll find that she's been very involved in the Indianapolis bar. She's very involved in her community. She has published cases. She has a large number of honors, including being named an Indiana super lawyer many years in a row. She has the 2009 President's Award for Service to the Indianapolis Bar Association. It goes on and on. So Nissa is absolutely one of the top family lawyers in her state, and it's a pleasure to have her here today. So Nissa, thank you for joining me.
Thank you, Dan. I appreciate it very much.
We're talking today about children and divorce and legal issues pertaining to children during and after divorce. And so I want to start with just the basics about children and divorce. Let's say a couple who has a child or children, and they need to figure out, what options do we have regarding co-parenting. Let's assume that both of the parties, both parents, want to have a role in parenting the children. What are their options from a legal point of view? Can they basically do whatever they want? And so where would they start with that?
In some ways, Dan, they can do whatever works best for their family as long as they stay within the parameters of the law. There's two main issues that a family will need to address in determining a custody and parenting time plan: legal custody of the children and physical custody of the children. And there's different considerations for each one of those, but in general, we always encourage our clients and our families to think about what are your children used to and what do you believe would be best for them going forward. Because you, as the parents, are the ones who know your children best, and as much as you can do to make that decision for your children, that's what's in their best interests.
So you're in Indianapolis, Indiana, and some of the people listening may be listening from another state. We know that there's distinctions from state to state. So what would you recommend that people do if they're listening in from another state regarding this conversation that we're going to be having? Should they contact the Bar Association, contact a family lawyer? What do you think would be best to get the best advice?
Either one of those. I would encourage people to consider that the information that I'm providing today is general in nature, and overall, it most likely will be applicable to the state in which they live, the general principles. But there are always going to be nuances in the law, and so after listening to this information and considering it, I would recommend that you follow up with an experienced family law practitioner in your area to get your specific questions addressed. Okay, well, let's start with, from what I understand, there's basically two types of custody. One would be sole custody, and the other is joint custody. It may sound obvious, but between the two, but can you explain what the difference is between those? Sure. Sole custody is generally in relation to the type of custody that we also refer to as legal custody. Sole custody means you are the sole decision maker. You are the one parent that can make final decisions related to your children. And as I stated, that's usually in regards to legal custody. In Indiana, legal custody is the idea that you have the ability and authority to make decisions for your child regarding your child's medical care, education, and religious upbringing. So if you are the sole custodial parent, you have the sole right to make those decisions. If you have joint legal custody, that means that you and the other parent, who now will be your ex-spouse, will have to work together to make those types of decisions for your child.
So how does joint custody agreement usually work? Is there a difference between joint legal custody and joint physical custody, or are they the same things?
There is a difference. Joint legal custody is an expectation that parents are going to work together to make the best possible decisions for their children regarding education, medical care, and religious upbringing. In essence, what we want are parents who are willing to communicate with each other, are willing to consider each other's point of view, and then are committed to trying to make the best joint decision for their children. Physical custody really is where do these children put their heads down at night? Whose house are they spending the most time at? Some people will talk about joint physical custody. Sometimes you'll hear the term shared physical custody. Sometimes you'll hear the term shared parenting plan. All of those terms relate to where is a child physically spending his or her time? How much time is that child spending with each parent?
So you talk about joint custody. There's a lot of conflict between the divorcing couple. Is it still possible to have joint custody?
It can be possible, Dan. However, I do think that the conflict between the parents normally will give a judge or a court concern. In Indiana, one of the factors a judge will consider is whether or not the family is a high conflict family. The question for the judge is going to be whether or not these parents are going to be able to put their conflict aside and work together and communicate effectively to share joint legal custody. If that is not possible, then the judge is going to find that one parent should be the sole legal custodian. Whenever I have a case where I have a long history of conflict, I always recommend that one parent have sole legal custody. This is particularly true if you have parents who have different religious beliefs or have significantly different beliefs regarding the use of medication, particularly if you have a special needs child. If these parents have a lot of conflict and you are dealing with a child that may have special education or special medical needs, generally it's best for one parent to have sole legal custody so that that parent can make sure that that child's needs are met.
So I think you've already touched on this in your previous answer, but with joint custody, you mentioned religion and probably when and where the child would go to school. Is there any other things that absolutely the parents must share and agree upon in a joint custody situation?
Definitely the religious upbringing of the child, medical decision making. The parents both need to agree on what medical treatment the child's going to receive, absent an emergency, of course. Where we see this become an issue most often is if you have a child who may be struggling in school, you may have a recommendation from a medical practitioner that child should be medicated, and you may have a parent, one who supports medication and one that does not. Those are typically the medical issues that we see parents struggling over when they have joint legal custody.
But you don't have to decide if their daughter, can wear X clothing to school or whether the child gets a tattoo or something like that. We refer to those as general parenting decisions. When a child is in your care, you as the parent who is physically present with that child, you get to make those general parenting decisions. What is the child going to wear today? Is it warm enough to wear shorts? What is the child going to eat today? Is the child old enough to ride his bicycle down the road and go down to his friend's house? Those are general day-to-day parenting decisions that can be made by the parent exercising parenting time. Let's say there's been a case where there's been domestic violence or child abuse allegations. Does the court, when making a decision about custody and access to the children, are they going to take those into consideration?
Absolutely. Those types of allegations are taken very seriously by most courts I've experienced with. In Indiana in particular, there's a statute that says that if a parent has been convicted of domestic violence, that parent has to have supervised parenting time for a period of time. A court is always, in protecting a child's best interests, going to be very concerned about any abuse in the home, whether that is abuse of a parent or abuse of the child or abuse of a child sibling in that home. So those types of allegations, You need to make sure that if that is happening in the home, that is definitely brought to the attention of the judge.
Now, you've been working with divorcing people for 17 years. Is it really possible to resolve child custody disputes without a lot of emotion and a lot of consequentially cost? How can you help to resolve when there's high conflict and high emotion?
I think there's always going to be high emotion when a family is trying to face a new reality. But what we try to encourage our clients to do is to think about taking control of their new reality. You, in this new situation, you have the power, the client, to decide what you think is best for your family moving forward. The ways that we achieve that they're numerous. Sometimes we can negotiate an agreement independently by working with opposing counsel on the opposing party. Sometimes we need a little bit more assistance, and we'll look at something that's referred to as mediation. That's a process where we try to sit down with a trained family law mediator that will work with both sides to try to reach an agreement. I always encourage our clients to explore those options and those possibilities, because at the end of the day, when you can resolve a matter by agreement and not have to go into a courtroom and not have to sling mud at the other person who is your child's other parent, that's always the best resolution. And in addition, when you walk in a courtroom, you are losing complete control. You are putting your family's future in the hands of a stranger who is a human being, and human beings can make mistakes. And that stranger knows nothing about your family. So I always ask my clients, why would you want to take that risk? You have an opportunity here to put your emotion aside, to not waste time and money, and for you and your soon-to-be ex-spouse to figure out what is best for your family.
So it sounds to me like your job as a family lawyer is to both quiet the storm that's going on and protect your client at the same time. Would that kind of capture what you're always trying to do?
Absolutely. It's always a balance of understanding how difficult the present situation is for our client, trying to recognize the emotions, the grief process that the client is going through, but also empowering the client to understand that while you may not be able to change the circumstances that brought you to this point, you can gather information, and information is power. I tell people this all the time. Knowledge is power. So you gather information, you educate yourself on the divorce process, you educate yourself on options, and then you use all of that information to work with your lawyer to try to manage not only financial risks, but also your emotional risks, and come up with an agreement and a parenting plan that is good for your family long term.
I noticed when I was reading through your bio that you also serve as a parenting coordinator. What exactly does a parenting coordinator do, and how can they help a divorcing couple who has children?
A parenting coordinator is really kind of a newer phenomenon in family law. I have been a parenting coordinator for about 6 years now, and it's the idea that you serve as someone that a family can work with after the divorce is final to try to do two things: minimize conflict if it is occurring regarding the parenting plan, and also to prevent conflict when possible. When I serve as a parenting coordinator, I'm appointed by a court, sometimes by agreement of the parties, and sometimes by just the judge's court order. I have a very defined role. I have defined duties of things that I can and cannot assist the family with moving forward. As a parenting coordinator, I try to help the parties resolve disputes about, for instance, holiday parenting time. What time are we going to meet to exchange the kids for Thanksgiving? I have a conflict on this weekend. I need to switch weekends. Can you help me figure out which weekend we should exchange? There's a conflict over summer parenting time. I can help draft calendars to try to prevent those conflicts from arising. We have a lot of conflict over extracurricular activities for children. I spend a lot of time as a parenting coordinator trying to facilitate communication between the parties and help them reach a mutual decision regarding activities for their child. The entire premise behind a parenting coordinator, again, is to empower parents to reach decisions on their own for their family without needing to involve a court in either some kind of post-filing litigation, whether that be a contempt petition or a petition for an order to allow Johnny to go to soccer or anything like that. It's the day-to-day management that sometimes if you just have a neutral third person involved, you can effectively make those decisions.
Nissa, as I'm listening, I'm thinking, my God, that is a challenging job. It's tough enough being a parent. It's tough enough having children. You've got to get in the middle of those folks who are fighting already and help them figure out what makes you want to do that.
It is. I tell people when I meet with them, my parenting coordination clients at the beginning, I say, I don't really do this to make friends. But, at the end of the day, I believe in families. I wouldn't be a family law attorney if I wasn't trying to help people in really difficult situations. And I feel like people who are using me as a parenting coordinator are experiencing a lot of stress in their lives. And if I can just help them work through all that stress and all that stuff, and if they blow off steam by talking to me, or sometimes they'll run an email by me, like a really angry email that they want to send to the other side, but, I'll pick up the phone and say, hey, look, we just need to tone it down a little bit. If I can help prevent that situation from getting even worse, then, I feel like I've done something. I've at least been somewhat effective in helping to minimize and I guess, possibly help remedy a very, very difficult situation.
I also noticed that you serve as a private guardian ad litem. Maybe you should explain what that is and what does that mean?
Sure. A guardian ad litem is a person who is appointed by the court to represent a child's best interests. Sometimes guardian ad litems are referred to as a CASA or court-appointed special advocate. The job of a guardian ad litem is simple: to be the voice of the child, to represent that child's interest in court. When you have a family that you've got parents that are divorcing, usually mom has a lawyer and dad has a lawyer. The child doesn't have a lawyer. The child doesn't have an advocate. And at least in Indianapolis, we have guardian ad litems appointed by our courts when there is a significant concern that there may be some kind of child abuse or neglect, or even sometimes false allegations of child abuse or neglect. I, as the guardian ad litem, am appointed by the court to do an investigation and to write a report to the court, letting the court know what I believe is in the best interest of the child related to custody and parenting time.
So what happens if the parents can't agree? What are the steps to creating a co-parenting plan, and who goes about creating that?
Well, if the parents can't reach a co-parenting plan, a lot of times we will work with the lawyers to try to reach a co-parenting plan. If that's not effective, then what I think is the best way to craft a co-parenting plan is to work with a trained family law mediator, to sit down and really think about, how has this family operated when the marriage was intact? What are these children used to in terms of a parenting plan? Are they used to, seeing mom and dad every day, whether both of them are working? Who usually takes the kids to what activities? And trying as much as possible to provide some level of normalcy for these children by incorporating parts of that past routine and as much as possible into the parenting plan moving forward.
You've already touched on this a couple of times about mediation, and I think you've said it a couple of times that you think it's better than litigation and trusting decisions to a judge who really doesn't know you and your family, right?
Absolutely. Absolutely. I've never regretted going to mediation. Even if I've not been able to reach a final mediated agreement, I have always learned something through mediation that at least helps me understand more clearly what the concerns are or the sticking points are of the other side, and at least allows me to prepare better for litigation or maybe focus my litigation strategy because of the information that I've gained through mediation. Mediation is a confidential process, meaning that whatever happens at mediation cannot be discussed or brought up in court. And that's necessary to protect the integrity of the process. Otherwise, nobody would ever participate in mediation. But in the event the mediation is not successful, I think from the client's perspective, you still have a much better understanding of what the issues are going to be when you go to court and what are the other side's arguments going to be and how can you best prepare to defend against those arguments.
Let's just talk about money for a moment, and that has to do with child support guidelines. Are they meant to cover all of the expenses relating to children, and really how is it determined, I guess, how much is to be paid from one parent to another parent?
This is probably the area where I believe is most state-specific, so my comments are limited to Indiana. But in general, we have child support guidelines that are designed to provide a certain standard of living for a child. And those guidelines take into consideration the gross income of each parent, and then also takes into consideration the amount that, someone much smarter than me that does math and figures this out, with the amount that a child should expect to need to live on based on that income level. And then child support, whatever that amount may be, is apportioned between the parents according to their relative income percentages. We also consider the amount of time that a child spends with each parent. Obviously, if you have the child in your home more, you are going to be incurring more expense for that child. You're going to be providing more meals. You're going to be washing, clothes more often. Your electricity is going to be higher. So that's another factor in the child support guidelines. But at the end of the day, child support is designed to cover basic expenses, but it doesn't cover things such as, haircuts and the extras. I like to refer to extracurricular activities. That is outside of child support in Indiana, and generally we have the parents agree, or they're ordered, but to pay for those extracurricular activities according to the parents' relative income percentages. So, for example, if dad makes 70% of the income and mom makes 30% of the combined income, dad will pay 70% of the agreed-upon extracurricular activities, and mom will pay 30%.
And so the custody arrangement, I think you've already stated this, but it does affect how much somebody is going to be paid in terms of the child support as well, right?
It absolutely does. In Indiana, our child support calculation has what is referred to as a parenting time credit, and that is basically a deduction from the child support payor's amount of support, and the deduction is based on the number of overnights that payor is spending with the child. And it can make things difficult because then you have parents who are motivated sometimes to either give less parenting time to the other side because they're hoping for more child support, or vice versa. But it is a factor, and it is something that we need to consider in negotiating our parenting time plans.
So just sticking with the paying child support, if a custodial parent doesn't allow the other parent to have access to the children, then can that non-custodial parent stop paying support?
No, they're two totally separate things, even though, I can certainly understand the emotional reaction of the parent who has to pay child support. But under the law, and this is very consistent throughout the United States, a child's right to child support, and it really is viewed as the child's right. A child's right to child support is not dependent upon whether or not a custodial parent is allowing parenting access to that child.
Yes, I want to thank you for your time. We could have gone on for another hour here, or 2 or 3, I'm sure. There's information that people listening might want to go to Nissa's website for. She has a lot of experience in out-of-state issues relating to divorce and child custody, paternity issues, step-parenting issues, and even grandparent issues who want to have access to their grandchildren. I invite you to go to her website and learn more about her and her firm, and there's information that they share on that website that would be helpful if you're having any of these issues that we've discussed, or really anything to do with divorce. Please visit bkrfamilylaw.com. I also encourage you to check out some of the other divorce school seminars that we have. There's lots of great information, and we'll be adding new seminars on a daily basis. And Nissa, thank you again for your time, and thank you
very
for
much,
listening.
Dan.
You're welcome. Take care.